you want to change this definition of marriage. And I said, you're the same age as me. Marriage has changed definition in my lifetime. In 1967, 13 states, it was still illegal to marry interracial marriages. And interracial wasn't just black and white. In Oregon, they couldn't marry Native Hawaiians. In South Carolina, it was Native Americans. So we've had these prejudices. And when 1967 came along, Loving versus the state of Virginia, only 20% of the people in the United States believed interracial marriages were appropriate. And you know the excuses they used? Interracial marriages, all about sex. They're unnatural. It's not in the plan of God. I mean, this sounds pretty familiar, right? Marriage has been defined by the Constitution of the United States to be a civil right. So don't let anybody ever tell you that you do not have the right to be married.
Given that we're in a time when there is much debate in regards to who has a right to marry and who does not, I wanted to post this video explaining the history of the marriage license. First of all, a marriage license is a document issued either by a church or state authority authorizing a couple to marry. The procedure for obtaining a license varies between countries and has changed over time. Marriage licenses began to be issued in the Middle Ages to permit a marriage which would otherwise be illegal, for instance, if the necessary period of notice for the marriage had not been given. Today, they are legal requirements in some jurisdictions and may also serve as the record of the marriage itself if signed by the couple and witnessed. In other jurisdictions, a license is not required. In some jurisdictions, a pardon can be obtained for marrying without a license, and in some jurisdictions, common law marriages and marriage by cohabitation and representation are also recognized. These do not require a marriage license. There are also jurisdictions where marriage licenses do not exist at all, and a marriage certificate is given to the couple after the marriage ceremony has taken place. Article 16 of the Universal Declaration of Human Rights declares that men and women of full age, without any limitation due to race, nationality, or religion, have the right to marry and to found a family. They are entitled to equal rights as to marriage, during marriage, and at its dissolution. Marriage shall be entered into only with the free and full consent of the intending spouses. For most of Western history, marriage was a private contract between two families. Until the 16th century, Christian churches accepted the validity of a marriage on the basis of a couple's declarations. If two people claimed that they had exchanged marital vows, even without witnesses, the Catholic Church accepted that they were validly married. State courts in the United States have routinely held that public cohabitation was sufficient evidence of a valid marriage. Marriage license application records from government authorities are widely available starting from the mid-19th century. Some are available dating from the 17th century in colonial America. But marriage licenses were not required until after the American Civil War. Marriage licenses from their inception have sought to establish certain prohibitions on the institution of marriage. These prohibitions have changed throughout history. In the 1920s, they were used by 38 states to prohibit whites from marrying blacks, mulattoes, Japanese, Chinese, Indians, Mongolians, Malays, or Filipinos without a state-approved license. At least 32 nations have established significant prohibitions on same-sex marriage. The marriage laws and license requirements of many states originated from the idea of eugenics. Eugenics is the applied science or the biosocial movement which advocates the use of practices aimed at improving the genetic composition of a population, usually referring to the manipulation of human populations. The origin of the concept of eugenics began with certain interpretations of Mendelian inheritance and the theories of August Weismann. Eugenics was widely popular in the early decades of the 20th century. The first International Congress of Eugenics in 1912 was supported by many prominent persons, including its presidents Leonard Darwin, the son of Charles Darwin, Honorary Vice President Winston Churchill, then First Lord of the Admiralty and future Prime Minister of the United Kingdom, August Forel, famous Swiss pathologist, and Alexander Graham Bell, the inventor of the telephone, among others. Eugenics was a controversial concept even shortly after its creation. The first major challenge to conventional eugenics based upon genetic inheritance was made in 1915 by Thomas Hunt Morgan, who demonstrated the event of genetic mutation occurring outside of inheritance involving the discovery of the birth of a fruit fly with white eyes from a family and ancestry of the red-eyed Drosophila species of fruit fly. Morgan claimed that this demonstrated that major genetic changes occurred outside of inheritance and that the concept of eugenics based upon genetic inheritance was severely flawed. By the mid-20th century, eugenics had fallen into disfavor, having become associated with Nazi Germany. This country's approach to genetics and eugenics have focused on Eugen Fischer's concept of phylogenetics and the Nazi twin study methods of Fischer and Ottmar Freiherr von Wescher. Both the public and some elements of the scientific community have associated eugenics with Nazi abuses, such as enforced racial hygiene, human experimentation, and the extermination of undesired population groups. However, developments in genomic, and reproductive technologies at the end of the 20th century have raised many new questions and concerns about the meaning of eugenics and its ethical and moral status in the modern era, effectively creating a resurgence of interest in eugenics. So we find quite clearly that the use of the marriage license was initially formed for the purpose of keeping interracial marriage prohibited as a form of eugenics. And as we battle today in the debate happening in the United States over same-sex unions, marriages, we're faced with the question as to who has the right to obtain a marriage license, and must a marriage license be obtained from the state to form a recognizable marriage union. This debate will most likely continue on for some time, even as we see states legalizing such marriages. It's important to recognize the history of the marriage license as we fight to, on one side of this debate or the other, so that we do so with full knowledge of the history of this license. It must be noted that none of the founding fathers of this nation up through the middle 1800s ever obtained a marriage license. Up to that point in time, mere cohabitation, as explained earlier, was indeed the forming of a marriage. And in some cases, if a person were churched or associated or a member of a church, they would have a ceremony in the church, and the church would issue a marriage certificate. Thank you for listening. I hope you find this information informative and beneficial.
2019, the marriage laws have changed dramatically in the state of Alabama, what you've got to do to get married. We're going to start here. As of today, Alabama does not issue marriage licenses. They've taken themselves, as they say, out of the marriage business. You cannot get a marriage license anywhere in Alabama today. Don't go to probate and expect to get a marriage license. It's not going to happen. If you have a computer and a printer, then I'm going to put the website up here so you'll know where to go. I've got it right here. Just bear with me 1 second, and I will put it up on the screen. To get married, this is where you go, right there. You see there, correct? And you will print out this. If you are 18 and above, you'll print out where it says adult. If you are 16 or 17, the form's a little bit different because you have to have a parent or guardian's approval to get married at that age, okay? So there's two different ways. If you're 16 or 17, don't get the adult one. Get the other one. Okay, 18 and above, this is the one. All right, so don't go to probate. If this is the 29th of August, if you've already gotten a marriage license, if you have already gotten a marriage license and you've not used it yet, and it's still within that 30-day period of time, and you plan on using it, like this weekend, or next weekend, or next weekend, here is the rules for you. On the day of the wedding, you've got to have two things. You've got to have a notary to notarize this. You still got to print this out. Even if you've already got a marriage license, you still got to print this out and have a notary to notarize it. Okay? Number one, you also bring that marriage license that you purchased from probate with you. And you've got to have your minister with a black ink pen, or your officiant, whatever he is, he or she. And they've got to fill out the bottom of that marriage license. And you've got to file both of these forms back to whatever probate. Now, if you got the marriage license has to be returned to the county probate office where you got the marriage license. This is different, but if you got that marriage license already and you haven't used it, and you're about to get married, you've got to return that along with this, both of these completed. The new one and the license, both completed, okay? So, you go to this website, alabamapublichealth.gov/vital records/marriage-certificates HTML. Okay, you got that right? And print that out. The unanswered questions as of yesterday have now been answered by the Attorney General. Yes, you can mail in this form after you've had it notarized. You don't ever have to go to probate. According to the existing law, you do not have to ever go to probate to get married. You don't even have to have a ceremony. You just have to get this paper, fill it out. You download it to your computer. It's a fillable form, so that when you download it, you can fill it out and then print it out and then get a notary to notarize it. You and your future spouse do not have to be together when you sign it and notarize it, and you do not even have to sign and notarize it on the same date. So one of you can sign and notarize it today. The other one of you can sign and notarize it on September the 25th, hypothetically. When you return this to probate, they're going to put your wedding date, your marriage date, as September the 25th. They're going to ignore the first date. They're going to take the second date. So you don't have to be together when you do this. You can mail this completed form back in. Make sure that whatever probate you send this to is going to return to you a certified copy of this, so you can get a name change. So you got proof you got married in Alabama, okay? Some counties may not do this free. Some counties may want another $15 fee on top of their filing fee. In Shelby County, where my office is, the fee is $86. And when you return this, if you include a self-addressed stamped envelope, they will indeed return to you a certified copy of this with your $86 fee. So once you get this signed, once you get it notarized, you put this and mail it to the probate office along with your $86 fee and a self-addressed stamped envelope so they can return to you a certified copy of this. All that probate is doing from this point on, from today on, is simply, very simply, all they're doing is recording this for the state of Alabama. That's all they're doing. It's like recording a deed. That's all it is, okay? So it's totally changed. Alabama's taking themselves out of the marriage business. Now, so you're getting married on a Sunday, a Saturday. Are you getting married in the evening, after hours, whatever? Check with your venue. I've talked to 2 or 3 vendors this morning, and none of them have a notary on their staff. Some are talking about getting a notary, but that doesn't happen overnight. They've got to get a bond. They've got to fill out an application, pay a fee, and then they've got to order their seal. So it can take a week, 10 days, or longer before they will have a notary on their staff. I'm encouraging them all to. If they do not have a notary, you're getting married on a weeknight at, say, Thursday at 6 p.m. Earlier in the day, go to your bank or somebody that's got a notary and get this notarized. Because unless you've got a friend or you want to pay somebody to be at your ceremony, you're not going to have the same date. If you think you're going to get this filled out the next day and have the 29th, in other words, if you have a ceremony today, but you don't get this notarized until tomorrow, the 30th, then your wedding date, your anniversary is going to be on the 30th, not the 29th. It will not fall on the day that you got your ceremony done. So, you're getting married on a Saturday or Sunday. Good luck finding a notary. Plan in advance. One venue I talked to, somebody had told them that, oh, they just got to have somebody witness something and you can get it notarized later. Not true. The state is going to take the latest date on here that it was notarized. No witnesses are going to get this done. No witnesses is going to secure your date. Only a notary is going to do this. On this website right here, there is frequently asked questions. You don't even have to trust me. You can read these frequently asked questions. Now, because there's such a deluge of people wanting to know what's going on with this marriage license, some probates are hard to even get through. In the state of Alabama, you can't even get through to anybody live. It's very difficult right now. So I'm answering these questions for you because I've done my homework on this, because I've married a lot of people. I've got a lot of couples asking a lot of questions, okay? So I'm going to recap real quick so you understand. If you have already got a marriage license prior to today, because nobody's getting marriage license in Alabama today. Nobody's getting marriage license in Alabama tomorrow. No time in the foreseeable future, based on the current law that went into effect at 12:01 a.m., nobody is getting a marriage license in Alabama ever again until they change the law. Alabama has taken themselves out of the marriage business totally. All you do is go to this website that's on the screen and print out this document. There's two different versions of this. One for if you're 16 or 17, because you need a parent or guardian's permission to get married if you're 16 or 17. If you are 18 and above, then you hit the one that says adult. You print this out. One of the spouses can have it signed and notarized today, tomorrow. That's not going to be your wedding day unless both of you have it signed and notarized today. But one of you can be over here in New York and have it signed and notarized, and then you can ship it off to your other one that may be in Alabama, may not, may be in Georgia, and they can sign and notarize it. When you file this back, the state's going to take the latter of those 2 dates. The state is going to take the latter date. If one of you signed this and notarized it on the 1st or the 29th of August, and the other one signed and notarized it on the 13th of September, guess what? Your marriage certificates will reflect 13th of September as your wedding date, not August 29th. Keep that in mind. But you don't both have to have it signed and notarized at the same time. Technically, in Alabama right now, you don't even have to be together to get married. Okay? Strange as it seems, you don't even have to go to probate. You don't even have to be together to get married. You don't even have to meet the person you're married to get married. But both of you have to get this notarized and returned. Put this in an envelope. You include the fee that the probate county requires to file this. In Shelby County, it is $86. With that $86 in Shelby County, if you send them a self-addressed stamped envelope, they will return to you a certified copy of this, which you will need for name changes to prove that you got married. You will need this, a certified copy of it. So I'm speaking for Shelby County now. Different probate, different rules apply to different probates, but I'm telling you, there's certain things that are good across the board, and that's what I'm trying to cover. Yes, you can mail this in. As of right now, the law says you don't ever have to go to probate to get married. You get this done, you get it notarized, you print this out online. If you don't have a computer and printer, I assume you can run by and get one of these, but get this online. print it out. Both of you get it notarized. Different times, different places, doesn't matter. They're going to take the latter of the two dates. They're going to take the latter of the two dates as your wedding date. That's going to be your anniversary. You cannot, regardless of what some people have suggested, you cannot have people witness your ceremony and then get this notarized another day. That is false information. Because as of today, no ceremony is required. No I do is required. No vows, no ring. None of that stuff is required. No minister is required. None of it. Zero is required. Okay? Just keep that in mind. All you need is this. All right? So I'm trying to keep it as brief and as plain and simple as to the point. We have contacted more than one wedding venue to see if they have had the forethought to have a notary on their staff. So far, the answer is no. Nobody has a notary on their staff. So you have got to, without exception, make sure you have a notary if you want September 1st to be your wedding date. If you want that to be your anniversary, you have got to have a notary that you can get this notarized anytime in that 24-hour period on September 1st. They don't have to be at the venue. They don't have to witness a ceremony. All they got to do is witness your signature on the date that you want as your marriage date. Keep that in mind. Very important. If you have any questions, I'm going to put my phone number, our phone number up here. We will do our best to answer these questions because there's a lot of confusion. I have spent a lot of time researching this with the state of Alabama, carefully reading over all this information, and there's a lot of false stuff going on. Very false stuff going on that we're trying to verify with these people, okay? So there you go. You cannot, I'm going to emphasize this because I was told by a very large wedding venue, one of the largest wedding venues in Alabama, they were told, and it was suggested to them that on the day of the wedding, that a couple of people could just witness the ceremony and you could get this notarized later. No, it does not work that way. Why? Because no ceremony is even required. No witness is required. Notary. If you want September 1 to be your date, it's got one of these has got to be the latter of the two dates over here. It's got to be September 1 that it was notarized. Bottom line, that's a fact. Yes, you can mail this back in. You can print this out online. You can fill it out. You can get it notarized, and you can mail it back in with the appropriate fee. Shelby County, it's $86. Again, in Shelby County, I don't know about Madison County. I don't know about Blount County. I haven't checked with them. It don't matter where you send this back to because the probate is really not doing anything with it. The probate's accepting it. They're going to stamp it, and they're sending it to the part. They're sending it right here, right on the screen. This is where each probate office is going to, it's just like filing a birth certificate. You can go to any health department in Alabama and get a copy of your birth certificate in any county. You don't have to go to the county you were born in. Any of them can print it out. It's going to be the same way with this. If you need extra copies of this certified for your records, with name changes or whatever, it's going to cost you $15 each for each certified copy. Okay? Keep in mind, as of today, Alabama is out of the marriage business. All you're doing is filing a notarized paper saying that we're entering into this relationship.